Hi, everyone, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So let's get into it. The most recent comment is from Brian Fay 874, and it's just from 21 hours ago. And he asks and says that he was hit by a bus about 2 months ago. He called the bus station office and told him his name and date of accident with their bus. He was calling to get their insurance information, and they told him that they couldn't give him any information and that he would have to call the police department, records department. It felt and sounded weird to him, and he's asking me what I think. So yeah, I mean, the bus company may have the information, but they may not want to give it over to you because, at this point it's an adversarial process, right? Because you're going after them and trying to get their insurance to pay. And for whatever reason, they don't want to give it to you. Now, if you had an attorney do it, the attorney has subpoena power. And to subpoena something is to call it forth. So if the attorney serves them with a subpoena, well, now they have to provide it, right? Or the attorney could file a motion and get a court-ordered subpoena if necessary. But what I would do is I would send them a letter to preserve everything. Preserve any video, preserve any incident reports, not to destroy any evidence, and I would contact an attorney as soon as possible. And in fact, if you need an attorney, just text me. It's 347-566-9595. Now, if it happened in here in New York, I can help you directly. If it happens somewhere else, whether it's Los Angeles, Atlanta, Georgia, Kentucky, it doesn't matter. I have lawyers, the best trial lawyers in each state, so I could recommend someone to you. And it won't be like that billboard lawyer who says, oh, I'm like, the best billboard guy and spends a lot of money, but he's not a real trial lawyer. What I do is I find the real trial lawyers, the people that go to court and get millions of dollars in court and have a proven track record of success. And those are the only lawyers I recommend. So yeah, just reach out. I'm happy to help you. But I mean, to answer your question, it is an adversarial process, and I guess they're really following the letter of the law. And since they don't have to give it to you, they're not giving it. But you know what? Even if they gave you the insurance information and you called that insurance company, don't think the insurance company is going to be fair. They'll offer you like $500 or something ridiculous. So if it was a real incident where you have any kind of real injury, what I recommend is getting medical care. Go to the hospital, urgent care, start a course of physical therapy, and then contact a reputable personal injury trial attorney in your city, or reach out to me and I'll help you find one. So that's the best course of action. Okay, and then Lonnie Matthias, 186, 22 hours ago, says, how about just rebuilding the system? And she's responding to my video about lawyer pushing you to settle. It's a short that we did about if the lawyer is kind of pushing you or forcing the client to settle, right? Because basically when there's a settlement offer, there's two things the personal injury lawyer can do. They can either say, okay, I have an offer. Let's say it's 100,000. I could push the insurance company to make it 200, 300, 400,000, right? To increase it. Or I could say, you know what? I have 100,000. I'd like that. That's nice. I could take $33,000. I can go buy myself a, nice vacation, whatever I want to buy. That's a lot of money. How do I make this happen? Well, the insurance company's not going to pay me any more money. I have to file a lawsuit. I have to fight. It's going to take years. Why don't I just push the injury client? That's the other thing I could do, right? I could tell him, hey, that's a good offer. Why don't you take it? I could ram it down the injury client's throat and kind of force them to take it. And that way I get my $33,000. So that's what a lot of lawyers do. It's kind of like a shortcut, but it's not the best thing for you, right? It's not the best thing for the injury victim. So he's saying, or she, I don't know, Lonnie, is saying, how about just rebuilding the system? It's a bad system. Looking at a way to change it will need everyone's help. Start by just talking to everyone. How would you change things? First you get rid of justified immunity all across the league system. Well, I mean, yeah, I guess changing the system. I mean, I don't know what exactly you mean by the system, changing the way lawsuits are handled. Sure. I mean, one of the issues with lawsuits is that, number one, they take a long time and there's no reason for it, right? Sometimes you have a simple case. A car rear ends another car. But to file a lawsuit, it doesn't take too much time, but then for them to answer and appear takes months. Then for them to see the judge takes more months. Now you have a year gone by. And then they schedule depositions where they ask you some simple questions like, what happened and what's your injury? But just to get the deposition done could take 6 months more. And now you're 2 years after, right? And then you file a note of issue and you certify it as trial ready. But then there's another year wait to get to a trial. So you're 3-4 years out and you haven't even had a trial. And if they choose not to be fair, if they choose to give you, let's say, instead of paying you $100,000 or whatever the case is worth, they choose to pay you like $5,000, what other recourse do you have except to go to trial? And now a lot of these companies like Uber are petitioning and lobbying and creating, these contracts that when you click through the app in order to use the Uber or Lyft, you're basically agreeing to give up your 7th Amendment right to a jury trial. So now they're taking away even that, even waiting 8 years and getting a jury trial is not available to you. Now you have to go to an arbitration with some corporate fat cat who's gonna give you 10 cents on the dollar. You don't want that. So there's a lot of things in the system that can be changed. There are a lot of problems. Tort reform, they're trying to put caps on damages in states, and that's not really the problem. The problem is that these insurance companies that are making like $93 billion a year are choosing to take all their profits and stick it in their pocket and refusing to pay injury victims. The problem is not that you need tort reform, the problem is that you need justified payouts and justice. So yeah, I agree with you, the system does need changing. Okay, and then Beauty Queen says, I slipped and fell, and I suffered a trimalleolar fracture with dislocation. I underwent 4 surgeries thus far. My ankle is riddled with arthritis. This was during work hours too. Yeah, no, I'm sorry to hear that. That sounds like a good case. The injury is very serious. If you slipped and fell during work, but if it's your employer and it's only your employer that was at fault, then it's a workers' comp case. But if it's a third party, then you have a third party personal injury case and a workers' comp case. So the way workers' comp will work is it'll pay you for your lost wages as well as your medical bills. It'll pay doctors and hospitals for your medical bills. But then to get compensation for yourself, there's a Section 32 settlement, at least in New York, from workers' comp where you can get a lump sum. But the big money comes from the third party action. So for example, you're working, but let's say a cleaning company comes into your office building and they're mopping and they leave a puddle and you slip on that puddle. Well, now this outside third party cleaning company, let's say ABC Cleaning, they're the ones, right, who caused and created the unsafe condition. So you sue them and you get the workers' comp benefits from your employer. So it's like 2 different things you can do. And those could be really big cases. So yeah, just feel free to reach out to us. It's 347-566-9595. Just text me. I'm happy to chat with you, give you a free consultation and help you. And we've been doing those cases in New York. We actually did a slip and fall case recently where we ended up getting a 1.8 million for someone. And then, we had another one that I did in the Bronx where we got 3.5 million. So there could be a lot of really big results with slip and fall cases, especially for a trimalleolar fracture. That's a serious fracture with dislocation. With 4 surgeries, it could be into the millions easily. And then Always Be Closing says, thank God I live in Texas, in response to the video, why do insurance companies offer low settlements in personal injury cases? And he mentions the power of the stower's demand. And you set a trap for the insurance carrier and the stower's liability is a plaintiff's best tool. Yeah, that's true. That's a good thing to have. The stower's demand in Texas, at least the way I understand it, is that if you give them an amount and then let's say, for example, they don't pay the amount and then you go to trial and you get much more than that amount, then they owe you, right? They owe you, it becomes like an open policy and they owe you a large, like a bad faith scenario. So that's good. That's really, really good. That's a good thing to have. I wish we had that in New York. Unfortunately, in New York, we don't have that. We have some kind of bad faith law, but it's more written in favor of the insurance companies. And so it's hard to get any kind of justice. And Joe Phantom says that's true about the lawyer pushing you to settle. Yeah, I really think that's not fair. The lawyer should not be pushing you to settle. Your lawyer should be getting you justice, full justice. So if you feel like you're getting a lowball offer and the lawyer is really pushing you to settle, that might be a good time to get a second opinion from someone else, because that's like one of the red flags. People ask like, what's a red flag, right? How do I know if my lawyer is doing a good job? Well, if you have, let's say, $1 million in insurance and you've had surgeries like one of these people brought like 4 surgeries, and all of a sudden the lawyer is pushing you and saying, hey, take 100, take 200. No, you know what? Ask him, have you found out if there's umbrella, excess, supplemental, or concurrent? Meaning there's layers, right? So you have 1 million primary, but what about the next layer? It could be 5 million more. A lot of lawyers don't even find out if there is or isn't the second layer or the third layer, right? And they're just pushing you to take the offer because it's easy money. It's like low-hanging fruit. It's right there, right? It's just take it and you're done. But if you have a trial lawyer who knows what they're doing, they can get you the million and maybe another 2 or 3 on top of that. So it's just a much better result for you. Sure, it'll take a little bit more time, but it's a completely different amount. You know, we're taking like 100 or 2 versus getting like 3 or 4 million, right? It's a different amount. It's a more of a life-changing value for a life-changing forever injury. And then NI5K says, this has been the worst scenario ever. Hot coffee burning your junk, and they have to talk about it in open court. He better get $1 trillion for the shame alone, in response to the $50 million Starbucks hot coffee verdict. And then someone else says, right, I mean, nothing would recoup that cost to your body. It's not worth it. I just don't want to be alive situation every day. I say 2 trillion. Yeah, I mean, definitely, it's a terrible thing what happened, because the guy had life-changing like burns, and he wasn't able to use his, you know, like his, it was a burn to his genitals, so he wasn't able to have like sexual relations. It would be painful instead of pleasurable, so it's a terrible thing. But yeah, I mean, it was a big verdict, 50 million, but if you actually look at the way that verdict came about, you see that a lot of it happened because of the corporation's refusal to be fair, because the lawyer, a few days after the verdict, did a podcast, and he explained, I listened to the podcast, and he explained that in the beginning, he wrote them a settlement opportunity letter, just like I talk about here. And he said, you know, I think it was for 19 million, and they called back, and there was some kind of talk of 13 million, and he said, you know what, my client will accept the 13 million. But then the corporation said, oh, we have a deductible, like the self-insured retention. And I think that was, I don't remember, it was either 3 or 5 million. But they said, you know what, we don't even want to pay that, because that's like the first layer. It's like their deductible, right? Like Starbucks has to pay that on their own. So they said, we don't want to pay that 5 million deductible, that self-insured retention. So therefore, you know, we're not going to pay 13 million because that's more than the deductible. So he said, okay, let's go to court then. So first they go to court, they win liability. So at this point they say again, well, now you've won liability, now it's damages only, right? So how much are you going to pay now? And there was talk now of maybe like 30 million. And the lawyer again said, you know what, I'll take 30 million, but on one or maybe on 2 conditions. Number 1, the settlement will not be confidential. I want it to be known because I want to make sure that other people don't get burned. And number 2, I just want you to send an email to all the Starbucks. You know, it's easy. You just send an email to all your Starbucks, all your employees, just saying, look, double check these lids, because if you hear the sound, the popping sound or the little whoosh sound, that means it's on, tight. But if you don't hear the sound, the lid's not on, and you're giving it to customers, you're like giving them a burn, like here's a burn, here's a life-changing burn. You're literally giving it to them because it's going to fall over. This was actually called a medicine ball, so it was like really hot tea, like 180 degree, I think 212 is boiling, and this was like 185 degree hot tea medicine ball that they gave him in a tray, but one of the lids wasn't on, so it just fell over into his lap, and he was wearing shorts. It burned his legs and genitals. So the point was, Starbucks responded to that by saying, oh, we asked corporate, and somebody in corporate said, no way, we're not sending an email, we're not going to do that, and we're not going to agree to no confidentiality. So then he asked his client, the lawyer said, look, it's up to you. You can take the 30 million without these terms, or we can go to court. And the client said, you know what, I don't care. I want to go to court, because even if I get less, I'd rather, you know, that no one else gets burned. I don't want someone else to get burned. He was like a really, you know, nice guy, good person, you know, truly injured. Wasn't one of these like fraudsters that you hear about, like that the insurance company wants to talk about. He was like a real guy. He said, look, I just don't want someone else to get hurt. So he said, okay, fine, let's just go to court. And then in court, the lawyer, in his closing argument, he mentioned, I think, a range between 75 to 125 million. And so when the jury came back, there were 12 jurors. They needed 9 of them to agree. 9 of them agreed to 50 million, and 3 others were crying. And the reason the 3 others were crying was because those 3, you know, you think maybe they didn't agree with the 50 million. Maybe they wanted to give 0, maybe they wanted to give less, but in reality, those 3 wanted to give 125 million. That's why they were upset. So yeah, so the verdict was 50 million, and with interest, because, you know, they had a chance to pay this much earlier, I think it becomes like 60 something, like 62 million under the California law, kind of similar to Stowers, where they did I think it's called a 998 in California. So anyway, that's the whole story. So they had chances. They could have got rid of it for 13. They could have got rid of it for 30, you know, but they chose all this, and now, you know, they got hit with 60. So, and now they're going to say, oh, like they did with the lady who got burned, you know, back in the 1980s, and they made it into, oh, hot coffee, you're getting $3 million. But the reason that lady got the money was because they actually made a choice. They said, do we change the tanks that are burning people, or do we just pay injury victims? And they said, changing the tanks is going to be too expensive. Let's just pay injury. Let's just keep burning people. We know we're burning people. Let's just keep burning them. And then we'll just pay them out. You know, pay this one 100,000, this one 70,000. And that's why when they found those emails that the McDonald's, or I think it was McDonald's back then, knew about this and was doing this on purpose, like literally burning people knowingly, that's when they hit them with punitive damages. And that's why that was 3 million back in the 80s. And then the insurance industry took it and totally did a spin and said that it was the injury victim's fault. And this is an example of these runaway nuclear verdicts, which is completely false. So yeah, now with this case, you know, we see what's really happening. And then Jackson says, hello, I got hurt at work after 15 years of working there. I had a first major surgery, then a fusion, then an SCS trial, and going on my 4th surgery, SCS permanent, 2 years without working, and workers' comp paying everything 100%. And he's asking for an average. Yeah, well, I'd have to speak with you. It's kind of hard for me to know this because, you know, I don't know what state you're in. There are a lot of different factors. For me to really give you a value, I'd want to know like what state you're in, what are the facts of what happened. Just getting hurt at work, like it's too general, right? Some people get hurt at work and you're entitled to 0. Some people get hurt at work and it could be a $10 million case. So how did you get hurt? What happened? Is there a third-party lawsuit? Is it straight comp? You know, where is it? I'm not familiar with this SCS, so I'd have to find out what that is, because we don't have that here in New York, SCS trials. So the best thing to do would be to just text me. It's 347-566-9595. And then Aiko says, I'm able to get the insurance claim adjuster to finally go to the repair shop tomorrow. And he's saying that, can we help with a little leverage with this scenario? Yeah, I mean, you know, it's not really a matter of us helping. I think there's not really much leverage that an attorney can do. What they do is they go to look at the car and then they just give you an appraisal of the car. If they're giving you an appraisal that's below like Blue Book value or something, you know, woefully bad, you could write a letter and explain to them why, and then they might raise it up a little bit. But there's not really much an attorney could do with the property damage adjuster in the repair shop. That's not really, you know, an attorney's role to be there. You know? But yeah, you could. I've definitely increased property damage amounts with letters or with phone calls before. Joe Phantom says, I got a letter from the doctor. He said that I need surgery, but I'll do it later, like in 20 years. You're good, great legal perspective. You're making things easy to understand the options. All right, and that's his response to a video I did about compensation for injury with or without surgery, right? Because a lot of people ask, well, the doctor said I need surgery, but for whatever reason, maybe I'm afraid, maybe I want to do it later. What if I don't do the surgery? So the answer to that is that, you know, of course, if you do the surgery, it's going to be worth a lot more. But if you don't do the surgery, as long as you can prove that you need the surgery and that you're going to have it and it's believable, people believe you, it's credible, you could still get compensation for the fact that you medically need surgery. So I guess the lowest amount would be like not needing surgery, not doing anything, right? Just soft tissue. Needing surgery but not having it would be the next tier, but then having it would be the highest tier. Here's a question from Linda, and she says, I got a TBI, that's a traumatic brain injury, and can no longer work, and I'm having serious symptoms from a drive-through chain car or car wash. I'm 58, and this happened in 2022. Is my case worse or worth more due to it being an established public company? I think so, yes, because if it's an established public company, one of the things that will be helpful to you is that they probably have a larger insurance policy, right? So if it's a public company, everyone knows about it, probably they have more insurance than as opposed to like one car wash that's owned by, you know, Joe Blow, and it's like a small car wash. Maybe they got the minimum insurance. And so, yeah, so I think in that sense, it should be a bigger case. But, you know, to get into the details, just text me. I'm happy to do a consult. And then DP says, thanks for the info. I'm about to have my first IME appointment soon, and my attorney said they will be sending someone with me. Your videos have been very helpful. Thank you. Oh yeah, no, I'm glad it helped. And he's responding to my video, you need to know this about independent medical exams. And they're not really independent, right? They're defense medical exams. The word independent is like in quotation marks because it's the insurance company's doctor. But it's good to send someone because that person known as an IME watchdog will, you know, hold the doctor accountable. Because if you have no one in there, the doctor could examine you really quickly, like, you know, 20 seconds or a minute, and say, you know what, I spent an hour with this person. And then they don't let you sometimes record or video record. How do you know, right? And then people just believe the doctor. They'll say, oh, why is the doctor? The doctor's not lying. He or she is a doctor, you know, whatever, from good medical school. They've been a doctor for 30 years. But the reality is a lot of these people are courtroom doctors. So they haven't done a surgery in like 20 years. And that's all they do is this medical legal stuff where they're hired by insurance companies. They see like 50 people a day. They have a cookie cutter report that you're not hurt. It's all from living your life, not from this trauma. And they just change the names and add in like one sentence and just, you know, send out 50 reports a day. And they see each person for a minute. So if you have this watchdog with you, the watchdog will say, entered the room at this time. This is what the doctor did, whether they used like a goniometer to check range of motion or whether they didn't, you know, all these things, everything very specific. And then you can use that report to then cross-examine the doctor at trial, or you could even call the watchdog and have the watchdog testify as to what they observed, and they have their report, their detailed report with them. So that's a good thing that the lawyer sends someone like that. And then Sheila says, can you recommend a lawyer in Los Angeles for a personal injury in a trip and fall? A neighbor had an illegal barrier of slippery stones, thorny plants, boulders, and almost invisible sharp metal obstacles in the parkway between the sidewalk and the street curb. After parking my car in an illegal parking area in front of their house because my garage door wasn't working, I tripped on the metal barrier and the boulder while trying to get to the sidewalk. My right hand was broken in multiple places and I suffered shoulder, back, and leg contusions and lasting pain. My life has been seriously disrupted from these injuries, and the doctor has said I will probably need surgery on my hand. I do not know where to turn for legal help. Thank you. Yeah, absolutely. Just text me, 347-566-9595. I know a lot of amazing trial lawyers in Los Angeles, like really good trial lawyers, some of the best. So, you know, depending on the type of case, some actually specialize only in premises liability. That's like what they do. Others are just trial lawyers that do all types of cases, whether it's trucking, slip and fall, premises liability, you know, trip and fall, slip and fall, whatever it is. So I could maybe speak with you a little bit and then I could recommend the best person for you, because it's really hard to do just with a comment, and it's better to contact me. And then also, of course, I need your information to have the lawyer call you or for you to call the lawyer and set everything up. So, and the other part of it is that the lawyer would have to accept your case. So I would have to explain a lot of things to them, or they might want to do a consultation with you directly. So the best thing to do is just text me, 347-566-9595. Peter says, one thing I will say, I am adamant on finding a lawyer who is willing to take their 1/3 settlement after, not before, medical expenses and other expenses are paid. This agreement would assure me that the lawyer representing me has my best interest at heart and is willing to be fair, as I don't believe I should endure the full burden of the expenses when it's my case that's producing the money. Does that make sense? I feel it's highly unethical to take 1/3 of the client's money and charge them fees and expenses. Right, so I guess like it depends on what you mean by expenses. Now, if you're talking about expenses that are needed to prosecute a lawsuit, like for example, filing a lawsuit is $210 in New York, you have to file a request for judicial intervention, that's $75. Those kinds of expenses. If I want to order your medical records, right, and the hospital says copying costs are $50, The way that works is the lawyer fronts the expenses, so he pays them up front. But then at the end of the case, the lawyer gets those expenses back. So the lawyer's not really making any money. They're just like spending $1, getting $1 back. They're left with zero, and they're taking 1/3 of the gross settlement. That's how it works. But if you're talking about expenses for medicals that you owe to doctors or hospitals, that's different, right? Because it has nothing to do with the lawyer. That's more like in New York, we have no fault. So sometimes the no fault will cover your expenses up to $50,000. But in a state where there is no fault, you have to pay the doctors back under a lien or a letter of protection. So it basically means you're getting, let's say, 3, 4, 5 months, whatever it is, of physical therapy, chiropractic, injections, whatever it is. It might be a $20,000 bill. Nothing to do with the lawyer. The lawyer just wants to take 1/3 of the gross, but then you owe that back to the doctor because the doctor's been treating you for free all this time, and then they want the money back, right? At some point, otherwise they'll never get their money. So that's just a method of payment. So I think medical bills, lawyers usually wouldn't agree to that because then their legal fee would be really little depending on your medical bills. But regular expenses, sure. I mean, you could do it like before or after. Some people do it on the gross, some people do it on the net after. But those expenses are usually low. They're usually like $1,000 or $2,000, unless you're going to trial and then you have to pay each doctor like say 10 grand to testify. Then you can get into some serious money. And then SARS Logistics says, I had an ACDF C5, C6 and post-surgery. After 7 months, C6 screws fell out, and adding a D-Trax. Those surgeries passed 2 years. Now I have reports saying I didn't need these from the beginning. What are my chances on malpractice? Yeah, I mean, I have to review the medical records and then I could recommend a strong malpractice lawyer for you. So just text me, 347-566-9595. But the other thing you can do, because I think I know SARS Logistics, I think we've talked before, because if you have another type of case, I think maybe he had a trucking case. If the case is still active, what you could do is all of these damages and these subsequent surgeries, you could just add them to the underlying truck accident or car accident lawsuit, whatever started the whole process. You don't have to sue for a different case for medical malpractice because at least in New York and in many states, medical malpractice is foreseeable as a matter of law. So that means that it just goes back to the underlying event, whether it's a trip and fall. I think this one was a truck crash, if I remember correctly. So you just get more money from the truck crash because you had surgery and then your screws fell out. So now you need this D-Trax, you need 2 more surgeries, whatever, it's called natural sequelae because it all, flows from the underlying event. So that's usually how it works. So you don't need to start another case, which would be a lot harder and very difficult to prove with medical malpractice. So yeah, you don't need to. Okay, so I think that's good. Thank you so much. Please like and subscribe to our channel. We're here for you. Our goal is helping serious injury victims and families. If you have any questions, just drop us a comment. We're going to do another live where we answer your questions live. If you wanted a video on a specific topic, just let us know. We'll do that. We're happy to do that. And all the best, everyone. Please stay in touch, and I hope everyone feels better and gets full justice on their case. Okay, have a great day, everyone.